My name is Kirsten Tynan, and I'm Executive Director of the Fully Informed Jury Association. With us today is Jay Schweikert. Jay is a policy analyst with the Cato Institute's Project on Criminal Justice. His work focuses on accountability for prosecutors and law enforcement, indigent defense, plea bargaining, and Sixth Amendment trial rights, including the right to trial by jury. Jay, thank you so much for joining us today.
Thank you for having me.
Recently, Jay filed a friend of the court brief on behalf of the Cato Institute in the case of Keith Wood, who many of you may have heard of since we have been reporting on his case for a couple of years now. Thank you so much, Jay, for doing that, by the way. I really appreciate that.
That was a very interesting case for us.
Great. Well, I'm going to ask you why in a minute, but let me start because I've had a number of our constituents ask that we please explain some of the legal terminology we use a bit better. And
Sure.
To that end, would you give us an idea of what a friend of the court brief is and how they play into court cases?
Sure, absolutely. So these are briefs filed by groups that are not parties to the case. They're not the plaintiff or the defendant, but there's some group that has some institutional interest in the outcome of the case. Sometimes this might be a more kind of business interest. If it were like a case about some regulated industry, they might file a brief kind of offering their perspective. But often it relates to groups that are like public policy groups or advocacy groups of some sort, where they see this case as related to their institutional interests. And that was certainly the case for us here. Cato Institute cares a great deal about defending First Amendment rights and free speech rights in general. And the Project on Criminal Justice, which is the part of Cato that I'm with, is extraordinarily concerned about the diminishing role of the jury trial in our criminal justice system. And so, that aspect of it drew our attention to this case as well. In terms of the idea, ideally, you, by filing one of these briefs, you're alerting the court to maybe sort of larger arguments than the ones raised by just the parties themselves. Maybe, you're helping them, either you're sort of supplementing the parties' briefs with, kind of a different take, or just making sure the court is aware of the larger context in which they're deciding the case. And so hopefully, the goal is always to, help the court sort of see things your way. And, even if it's not necessarily going to change which way it comes out, to kind of influence how the decision is written, and, sort of get, try to, shift, maybe, hopefully get the opinion kind of written in a way that's aware of the concerns that you're talking about. Different judges in different courts have different attitudes toward them. So it's always, a little unclear how much of a difference they're going to make. But I mean, they get cited quite a bit, both at the state level and the appellate and the federal level. And, a lot of times parties, ask for amicus, or I said amicus because the phrase amicus curiae is Latin for friend of the court. So these are often called amicus briefs. They're usually interested in amicus support. So, that itself is some indication that they think it makes a difference to how their case will come out.
I think I was told early on when I inquired if Cato would be interested in this case that typically your organization doesn't get involved in state cases until they get to a really high level, like the state Supreme Court level. What piqued your interest in this early on? We're now at the Michigan Court of Appeals level, which is, I think, one step below the Michigan Supreme Court.
Right. Well, so, in general, it's probably true that most of the time, most groups, Cato included, is more likely to file briefs once they reach, the highest levels, either the U.S. Supreme Court or the state Supreme Courts. Our group in particular, the criminal justice group here, has been more active generally in filing it at the appellate level, both at state and federal courts, partially because we want to get involved in interesting cases while they're still developing. In some ways, I think actually, even though amicus briefs there are a little bit less common, I think they can make even more of an impact because they signal that this is something really important to be taken seriously. I mean, I think especially in this case, there are really serious free speech implications and implications for jury trial rights in general here that I think the lower court was a little bit glib about. I mean, and so, we wanted to make sure that we, could do our part to sort of signal this is a huge, important issue, even though the level of consequences, weren't that high in terms of I mean, in terms of the amount of time he was going to have to spend, incarcerated. The idea that this is something that someone could be criminally punished for is a huge blow to our Constitution in a lot of respects. And so we wanted to, lay out everything, all of those issues here very clearly, so that not just so that we could have an impact on how the case was resolved, but also just to signal that it's something that was worth taking very seriously.
And in addition to the Cato Institute, not only FIJA, but also apparently the Michigan ACLU filed friend of the court briefs. Does that collective sort of across the board, I think in one article it was referred to as a bipartisan effort, although I don't think any of us is officially partisan.
None of us are officially partisan.
No.
But that broad coalition of different groups, different interests, and different goals, that can speak volumes, right?
Mm-hmm.
And that's something that we often look to in terms of amicus campaigns, is coalition building, right? Because if you can get, Cato and the ACLU and FIJA and all sort of either on the same brief or kind of on the same side, that shows that there's a lot of reasons to take this
Mm-hmm.
seriously. And I think it's actually, especially in the criminal justice space, that kind of coalition building is a lot more common than I think people might naively expect. I think a lot of tradition, I mean, look, I'm a libertarian, so I don't really buy into the traditional left-right divides that much anyway. But I think especially in the criminal justice space, that really breaks down.
Right.
There are a lot of people, conservative, liberal, whatever, who have the same basic set of concerns about, amongst other things, the diminishing role of the jury trial in our criminal justice system.
Now, specifically with regard to Keith's case, just as a general summary, Keith was basically arrested for handing out FIJA brochures on the public sidewalk outside a county courthouse, I believe.
Right.
You note early on in your brief that it was on the public sidewalk, and what is the significance of that particular location as opposed to anywhere else he might have been?
Sure. So public sidewalks are the quintessential example of what the Supreme Court has usually called a traditional public forum, meaning some space where that is historically and our legal constitutional tradition has been a place where core political speech takes place, and people expect and routinely engage in civic advocacy on a wide range of subjects. Now, none of that is to say that his speech wouldn't be protected if it took place somewhere else, but just in terms of what kinds of regulations legislatures can make regarding certain speech aspects, it tends to be even harder to make those kinds of regulations in what the court has called traditional public fora. So that really, the fact that this was in that quintessential location, I think really highlights how this is really ground zero of the First Amendment. Right. I mean, the First Amendment is a broad provision. It protects a lot of activities. And I don't mean to sort of suggest that anything short of this shouldn't be protected. But I mean, here you're talking about handing out pamphlets, like classic political advocacy, on a matter of public concern older than Magna Carta, right? The independence and prerogatives of citizen jurors in a traditional public space. So if that's not protected, what is?
That was also my impression. It seemed like if we lose the public sidewalk, which seems to be the most protected area for First Amendment purposes, then if we lose the public sidewalk, we sort of lose it all.
Right.
So yeah, I'm glad that
to some extent it also matters because some of the arguments here about why this could be restricted were because it was in proximity to a courthouse, as if that sort of made it more problematic and more like a more sensitive concern, whereas we're trying to say, like, no, the exact opposite is true. The fact that this was on a public sidewalk in front of it, there is no more public space than a sidewalk in front of a courthouse. So if anything, if you want to sort of draw, I mean, I think that this speech should be protected regardless of where it takes place, but if you want to draw anything from it, the location means it should be more protected, not less.
Now, I know that the United States Supreme Court has some restrictions on its rather large plaza outside,
right.
which seems to conflict with this argument that I definitely agree with you on, that should be more protected. Do you think that is of particular significance in these cases other than the Supreme Court, or is there something that distinguishes the Supreme Court situation from other courts?
I mean, I'm not intimately familiar with what all of the Supreme Court's rules are in terms of their space. I mean, there may well be, for instance, security considerations there that are different than they are for some state courts or even maybe federal appellate courts. I couldn't really speak intelligently to that. In terms of the kind of substantive rules of what you are and are not allowed to say, I don't see any reason why that should be different. And I mean, and look, I mean, it certainly is the case that courts are very protective of their space and what can be said there, and there are some difficult lines to draw in terms of I mean jumping ahead a little bit. I mean, what I think you guys mentioned in your brief and we mentioned it in ours, that certainly protecting the integrity of jury trials and is an important compelling state interest, and there's a lot that it is proper to do along those lines. But I think it's easy to see that courts have, I think, run away a bit with what kind of speech about their cases they can prohibit, even if those don't go to traditional concerns about jury tampering.
I'm glad you brought up the point about content, because there seems to be a very specific argument, if I understand it correctly, that the prosecution is making. It seemed to me, and stop me and correct me if you have a different understanding,
Mm-hmm.
But it seemed like they were saying that handing out these brochures in general, even in that location, was not jury tampering, except for the fact that Keith had some knowledge about a case that might have been going to take place in court that day, and that suddenly that magically makes it jury tampering. Is that your understanding?
I think that's right. I mean, so if you look at the so-called jury tampering statute here, right? I mean, part of one of the elements there is attempting to influence, right, by argument or persuasion. And so, as I understand the prosecution's argument here, it's like, well, he intended to be influencing jurors with respect to some particular case. And I think our basic point is that may or may not be true. I mean, that was, I think, a factual question that was contested below, and I don't have expertise on that. But the point is just that doesn't, whether or not that's the case, it doesn't take it out of the ambit of the First Amendment, right? I mean, we're talking here about arguments that you can't make, right, on a particular subject matter, right? I mean, the statute specifically regulates, quote, argument or persuasion, right, on a particular subject matter, jury decision making. That's content based. I mean, under very clear Supreme Court case law, the most notable case being Reed v. Town of Gilbert, which is just a few years ago in 2015. Supreme Court has been very clear that a law is content based and therefore subject to strict scrutiny, which means it's going to be very difficult to establish the constitutionality of it. If it if the speech at issue, if whether it's speech regulation is content based, if you have to look at the content of what is being said to determine whether it falls under the regulation. And that's exactly the case here.
Right.
If Mr. Wood had been handing out pamphlets about his church or trying to sell his car or advocating, voting for or against someone in an upcoming election, he wouldn't have been convicted. He wouldn't have fallen under the statute. It's because of the content of what was in the brochure. So I think it is the case that they said he had this requisite intent, and that's part of the elements of the statute as well. But that doesn't get you out of the First Amendment inquiry, because under very clear case law that I think the lower court here completely misinterpreted, this is a content-based regulation, and therefore it's got to be narrowly tailored to a compelling government interest to survive. And not only do I think that it doesn't meet that standard, but the lower court didn't even apply that analysis. It didn't even think that there was a First Amendment question at issue.
That was very surprising to me as well, because it seemed like my impression was that it seemed like a lot of it was kind of decided before it was even argued, really.
Yeah, I think that's fair.
So in that regard, I am glad it's at the appeals court level, because that will have wider implications, I think, than if it had just been decided at that level. And that will send a broader signal about how these sorts of questions need to be examined. Now, in your brief, you also talk about some of the wider things that would fall under restriction of this law if it's
Hmm.
upheld, and it got pretty broad.
Yeah, well,
It was,
it's a broad statute.
yeah,
Um,
it
it
involved things that don't even take place even anywhere in the presence of jurors.
That's right, because the statute's not. It's this is actually in one of the things we included in our brief is a comparison of this statute to uh, really the so-called jury tampering statutes of a lot of other states in the country, and this is one of the single broadest ones in the entire nation,
Mm-hmm.
because it's not limited to speech about a particular case. It's not limited to speech uh, directed to or made in the presence of particular jurors. All that matters is if you intend to influence a juror or not. So it would cover, for instance, a radio personality making a general point about, we're having too many spending too much time and money locking people up for harmless drug offenses. So jurors, you should stop voting to convict these people, right? That falls under the plain terms of the statute. It would apply to a newspaper ad about a case saying, I've looked at this carefully, like an op-ed saying, this defendant was clearly framed, so the jury should vote to acquit.
Mm-hmm.
That would fall under it too. It would apply to intimate conversations between family members, where if one of them is called for jury duty and one of them reminds them, remember that that there was that local story about police getting caught perjuring themselves and planting evidence. So don't necessarily trust anything you hear from a police officer. That would fall under it too. So there's this huge range of what I think almost any person would recognize is protected speech that is implicated by applying this statute as broadly as the lower court seems, as broadly as its terms suggest, and as the lower court seemed to think was perfectly acceptable.
Now, before I wrap up, I'm just going to throw an open question to you. Is there anything else that you found particularly notable about the case that we should probably mention to anyone viewing this?
Well, so I think, we've talked mostly about the sort of free speech side of things. And I think that's a huge part of it. And doctrinally, that's kind of what's doing the most work in the case, in terms of, this law is unconstitutional as under the First Amendment, right? But we were also really interested in it at a larger level because of the jury trial implications. I think it looks like from the record here that even though the statute is not written in these terms, the prosecutor and the district judge below were really concerned about the sort of so-called jury nullification advocacy here. And that's something that Cato was concerned about a lot. There's I'm sure you're aware of this, but a book by a Texas attorney, Clay Conrad, called Jury Nullification, The Evolution of a Doctrine, which was recently republished by the Cato Institute to get a wider distribution for that subject. In some ways, I have to say, I don't love the term jury nullification because I think what it suggests, the word nullification suggests that there's something extra lawful, or it suggests that
in some way,
right? It suggests that it's an exercise of civil disobedience as opposed to an intended part of our criminal justice system, which I think is historically the case and is proper, right? I mean, if you look at throughout not just our nation's history, but throughout Anglo-Saxon law going back for over a millennium, the role of juries was in part to serve as a check on state power, and to refuse to return guilty verdicts if doing so would be a manifest injustice. We've kind of decided today that juries are all about just fact finding, right? And that's really the main and almost sole goal. And frankly, that may be something that juries aren't necessarily that great at sometimes. I mean, I don't know that that's the unique strength of jurors. I think
especially when it's filtered before, like all the information is filtered before it even gets to them.
Exactly. I mean, I think especially in the criminal justice space, the main role of juries are based on transparency, accountability, and legitimacy. It's to say, before you can impose the harshest powers that the state has to lock people up or even to take people's lives, you you have to go before the public and you have to justify what you're doing, justify factual guilt and the legitimacy of this prosecution. And if you can't make that argument, if you can't convince, a jury that this is a just, lawful, exercise of government power, you shouldn't be able to do it. So, and this is, I think, this is especially problematic today because we have nearly eliminated jury trials from our criminal justice system. At the federal level, 97% of criminal convictions today are obtained through plea bargaining. The state level, it's about 95%. So we've taken this institution that is at the heart of our Constitution, that is intended to be the way we do criminal justice in this country, and we've made it at best an afterthought. The default now is basically whatever prosecutors decide is reasonable. Prosecutors have enormous power and leverage in plea bargain negotiations. So that's one of our larger structural concerns, and it's not an easy question, right? There's no simple solution to that. But I think, and why bringing it back to this case, the least we can do is not single out for punishment speech about the, historic centrality of the jury trial and the role of juries as independent checks on government power. It's not as if protecting that itself is going to fix this problem, but we could certainly avoid making it any worse. And that is what I see the state doing in this exact case, is they are exacerbating what is already a critical problem.
Right. My experience with our volunteers and other people who want to do this kind of juror rights education is that even though by and large we are on the winning side in these kinds of cases almost all the time, and the time I've been with FIJA, just the mere fact that people are getting threatened and arrested and charged is scaring people away from this. It's chilling their willingness and comfort with doing something that is perfectly legal.
Right.
And people who are not, engaged in that or are looking to engage in that, just they see the news stories about someone getting arrested and they don't see a lot of stories about them being, having the charges dismissed, being acquitted, etc. And
right.
So just the mere fact that courts are making these moves, even though they turn out to be in the wrong almost every single time, it's really putting a significant damper on efforts to spread exactly that information. And I think they know that. I believe that they know that even if they lose, they win, in a sense.
Yeah. No, I think that's right. And I think, and that is also part of why I think, groups like FIJA and Cato getting involved in these cases is important, not just to affect the ultimate doctrinal outcome, but to bring public awareness to this, to make sure that people know that there is, there are legal principles at stake. And, so, we've certainly tried to publicize this, as, to our network, and to make sure people are aware, that this is not, this shouldn't be the norm. Right. But you're right. Prosecutors and courts have enormous power to influence people, even if what they're threatening or doing is unlawful, because most of the time they can get away with it. Or even if they can't, the cost. And it seems like here Mr. Wood is someone who's like, really committed to this cause and willing to fight for it. Most people aren't. Most people, even if they know they're in the right, even if they know they could fight it and ultimately win, they're going to be tempted reasonably to take a plea, right? To take a simple out and just be done with it and move on with their lives. And there's nothing wrong with that. people are allowed to make those decisions. Right. And the fact that people are willing to do that is what gives prosecutors so much power, because they know they have that leverage. And we can make this all go away if you just take a guilty plea. Yeah.
And it's understandable too, because the government essentially has what I like to call the magic checkbook. They have a significantly less limited pool of funds than an individual such as Keith.
Of course.
And they knew that. They crippled him, I think, from the beginning by slapping, I want to say it was a $100,000 bond or a $150,000 bond on him, like the day before Thanksgiving, to get out. Wow. For handing out pieces of paper. I looked, some states for accused murderers, the bond is like $50,000. So I'm flattered that our material is considered that significant, I
Twice
guess.
as serious as murder.
Right. But at the same time, it's clearly a tactic that's been used to cripple people's ability to fight back. Because Keith's the sole
Hmm.
income earner in his family. He runs his own business. It's not, if you can't just be in jail for a few months while you have 7, 8, now 8 children
Right.
and a wife depending on you for support. So I just want to say I appreciate so much everything that Cato is doing on both the free speech topic and the jury rights element. Thank you so much for getting involved. I was so happy to see your brief. I can't even tell
It
you.
was, I mean, it's a very interesting case to work on, and so I'm really glad we had the opportunity.
And I should point out, neither you nor I could have done this without some folks in Michigan helping us out. We needed some attorneys in Michigan to file this for us. So I want to give due credit and thanks to Mark Randazza, who actually isn't in Michigan, but who connected us with 2 Michigan attorneys, Eric Misterovich and John DiGiacomo. Hopefully I've pronounced those correctly because I haven't met either of those gentlemen in person yet. And of course, we have to thank Roger Roots, who wrote the FIJA brief. Looking forward to seeing how this turns out. I have not yet heard what time frame we would be expecting any sort of resolution on this. But as soon as I hear something,
Yeah.
everyone will hear something as well. And if you hear something before me,
Well,
I
I'll be
will,
sure to let you know.
I will
Yeah.
definitely be waiting.
So, yeah, but no, the attorneys you mentioned at Revision Legal were extraordinarily helpful. Took care of all the logistics and handled our, a lot of structural and formatting style questions. So,
Mhm.
absolutely indispensable part of the process.
And I will say also from FIJA's perspective, we have a very tiny budget. I'm our only staff person. We have no attorneys on staff. So the fact that they were willing to do this on a volunteer basis was just a godsend. We really, this is kind of, our main mission is to do the work of educating on jury rights. This supports that, but it's not the main focus of our mission. So we really couldn't be doing this without that kind of support. And obviously, it's a huge boon to have an institution such as the Cato Institute really get involved at a level that we couldn't necessarily do. So thank you so much, Jay. I'm going to wrap it up here and chat with you for a minute afterward. But
Sure.
once again, Jay Schweikert of the Cato Institute's Project on Criminal Justice. Thank you so much.
Thank you.